Some of my previous videos caused people to ask the question, what happens when your child gets in trouble with the police or with the law in general? And specifically, what might happen to children under the age of 10, which in England and Wales is the minimum age of criminal responsibility. So what happens if your child gets in trouble with the police? Well, the short answer is that you, the parent or the guardian or the person with parental responsibility, can be held responsible for your child repeatedly getting into trouble with the police, or if you do not take reasonable steps to control their behaviour. If there are persistent events in which your child gets into trouble and this leads people to question you and your responsibility as the parent or responsible person, you might be asked to attend a parenting programme. You might be asked to sign a parenting contract, which will set out what you are supposed to do to keep that child under control. You may also be given a parenting order by a court. Each of these are designed, however, to support you in preventing your child from getting into further trouble with the police again and again. These sort of things are ordinarily voluntary, but as I said, a court may step in if necessary to give you a parenting order, which will again set out various things that you are supposed to do as the person responsible for that child. Parenting programs are run by youth offending teams and other organisations within the justice system, and sometimes charities. The program will be designed to set out how to assist you in parenting that child to prevent them from getting into trouble and to help to control their behaviour. A parenting contract is often seen as one stage further, which is a contractual agreement whereby you are signing to agree to certain conditions, usually again with the youth offending team. You will all agree to undertake certain steps and responsibilities to ensure that this child stays safe and away from crime and other disorderly behaviour. If you are put in the position of being asked to sign a parenting contract and you refuse to sign it, then the case may end up going to court and the court may make a parenting order against you if ultimately you refuse to sign the agreement. The final step in this progression, of course, is the parenting order itself. This is where the court will set out various things that you and your child must and must not do, and they can last up to 12 months. Don't confuse a parenting order with a criminal record, however. This is just an order of the court which is setting out what you and the child must or must not do. But you can, however, be taken back to court if you refuse to obey the order. This ultimately would be contempt of court because it would be willful breach of a court order. Circling back, what happens if a child under the age of 10, which in England and Wales is the minimum age of criminal responsibility? Well, children under the age of 10 are treated differently when they break the law to adults, but that doesn't mean that they just get away with their behaviour. Whilst children under the age of 10 cannot be charged with a criminal offence, they can be given a local child curfew, meaning that they cannot be out in a public place between the hours of 9 p.m. and 6 a.m, unless of course accompanied by an adult. A local child curfew can last up to 90 days, and if broken, then the child can instead be given a child safety order. And children under 10 that regularly break the law can sometimes be taken into care, or their parents can be held responsible for their actions. If a child under the age of 10 has committed a serious offence or broken a local child curfew, then they can be placed under the supervision of the youth offending team once again. This is known as a child safety order. As I said, it will typically last for up to 3 months, but it can be extended and last for up to 12 months. And ultimately, as I said previously, if a child doesn't stick to the rules of a child safety order, then the court can consider whether the child should be taken into care. So as a broad summary, as I said, children are treated differently to adults when they commit offences, and there are different systems in place to help control their behaviour. And the system is ultimately designed to try to control and improve that behaviour. Although children over the age of 10 in England and Wales can be given sentences, they will generally be given different sentences to adults and dealt with by the youth courts, which incidentally are private proceedings that the public cannot go and see. If they are taken into some form of custody, it will be a special and secure centre for young people rather than an adult prison. However, someone that has reached the age of 18 is still considered a young person, and between the age of 18 and 25 will be considered a young person and not a full adult. But if they are sent to prison, they'll be sent to a place that is designed to hold 18 to 25-year-olds rather than a full adult prison. So all in all, a child doesn't just get away with committing crimes, but there are systems in place to help to improve their behaviour. So I hope this has served to address some of the questions, so please remember to like and subscribe, and thank you for watching.